Now, I'd like to invite our second speaker, Professor SAVADOGO. Professor Louis SAVADOGO is a senior lecturer at Université de Cergy-Pontoise at Paris, and also special rapporteur on prevention and repression of piracy and armed robbery at sea.
Thank you, Mr. President. Let me first of all thank the organizers for their kind invitation and the opportunity I have been offered to present a topic under consideration by the International Law Commission. The structure of my presentation is as follows. I will first present the background of the topic. The second part will focus on some key issues that the ILC has decided to consider. Let's start with the historical background of the topic. At its 33rd session in 2022, the International Law Commission decided to include the topic prevention and repression of piracy and armed robbery at sea in its program of work and appointed Mr. Cissé as special rapporteur for this topic. The ILC requested the Secretariat to prepare a memorandum on the topic addressing in particular elements of previous work of the ILC that could be relevant for the future work on the topic and the views expressed by states. The memorandum would also concern writings related to the definition of piracy and armed robbery at sea and regulations adopted by the Security Council and the General Assembly of the United Nations relevant to the topic. The General Assembly, in its paragraph 7 of the Resolution 77/103 of 7 December 2022, subsequently took note of the decision of the Commission to include the topic in its program of work. At its 74th session in 2023, the Commission considered the first report of the Special Rapporteur, which addressed the historical, socio-economic, and legal aspect of the topic, including an analysis of the international applicable law to piracy and armed robbery at sea. In that report, the Special Rapporteur reviewed the national laws and regulations and judicial practice of states regarding the definition of piracy and the implementation of treaty and customary law. The Commission had also before it a memorandum prepared by the Secretariat. This memorandum provided elements of the Commission's previous work that could be of particular relevance to the future work on the topic, as well as the views expressed by states and the resolutions of the Security Council and the General Assembly. Following a debate in plenary, the Commission decided to refer draft Article 1 to 3 as contained in the Special Rapporteur report to the drafting committee. The Commission provisionally adopted draft Articles 1 to 3 together with commentaries. At its 75th session in 2024, the Commission considered the second report of the Special Rapporteur and the second memorandum prepared by the Secretariat concerning the topic. The memorandum provides information on the treatment of the provisions containing the definition of piracy in the 1956 draft articles of the ILC concerning law of the sea, views expressed by states at the first United Nations Conference on the Law of the Sea, which resulted in the adoption of the 1958 Convention on the High Seas, and at the Third United Nations Conference on the Law of the Sea, which resulted in the adoption of 10 December 1982 Convention. Following a debate in plenary, the Commission decided to refer draft Article 4, 5, 6, and 7 as contained in the second report of the drafting committee, to the drafting committee, taking into account the views expressed in the plenary debate. The Commission took note of draft Article 4. At its 75th session, after the resignation of Mr. Cissé, the Commission appointed me as Special Rapporteur. The Commission requested the Special Rapporteur to draft a document on the topic as a whole and its future direction. At its 56th session, the Special Rapporteur submitted a note. In this document, he identified point of law, which, in his opinion, could constitute the major themes of the work of the Commission on the topic. He also outlined general areas of inquiry based on the main features of the topic and provided methodological guidance addressed to the members of the Commission to focus their work. On 28 April 2025, the Commission decided to establish a working group on the topic to consider the note of the Special Rapporteur and appointed the Special Rapporteur as chair of the working group. Let's turn now to the study resulting from the note produced by the Special Rapporteur and approved by the ILC. Several members of the working group welcomed the proposal of the Special Rapporteur to study emerging issues related to the topic, including the carrying of armed security personnel on board merchant ships, as well as legal questions linked to arbitrary seizures of ships under Article 106 of the UNCLOS. Several members supported further clarification of the meaning of the term prevention and repression. The examination of other legal issues, notably those addressing the use of new technologies, including uncrewed aerial vehicles, maritime autonomous vehicles, and cyber attacks, was also considered useful. Several members of the working group expressed their support to the proposal of the Special Rapporteur to discuss the matter of universal jurisdiction in relation to the repression of piracy. Members of the working group also recalled the interest expressed by several states in the Sixth Committee in including the rescue of victims and assistance to victims of piracy in the work of the Commission on the topic. The possibility of examining the jurisdictional complexities resulting from acts occurring across multiple zones was also raised. On the repression of pirates, attempts to create a specialized international jurisdiction have been unsuccessful up to date. However, it is worth mentioning the Protocol on Amendments to the Protocol on the Statute of the African Court of Justice and Human Rights, which has jurisdiction to prosecute pirates under Article 28A. Pirates arrested by third states or states involved in a multinational police operation at sea are transferred to states concerned, mainly Kenya, Mauritius, and the Seychelles, based on extradition agreements concluded with the European Union and other states such as China, Japan, the United States of America, and the UK. It is worth recalling the matter of universal jurisdiction in relation to the repression of piracy. The peremptory or jus cogens character of the crime of piracy and the obligation to extradite or prosecute are examined. In a number of situations, the case has been decided by a specialized chamber of a domestic court. International courts and tribunals may have jurisdiction in matters of interpretation and application of the relevant international agreements. The International Tribunal for the Law of the Sea, for instance, has both contentious and advisory jurisdiction. In particular, it has jurisdiction over any dispute concerning the interpretation or application of the provisions of the UNCLOS, submitted to it in accordance with Part 15. Therefore, the tribunal has jurisdiction to deal with any dispute between states related to piracy. However, it does not have jurisdiction to prosecute pirates. The tribunal, as full session, may give an advisory opinion on a legal question if an international agreement related to the purposes of the convention specially provides for the submission to the tribunal of a request of such opinion. In this regard, the tribunal may be requested to clarify through an advisory opinion issues related to arrest of pirates in the territorial sea, or whether under international law, a non-arresting state has authority to try pirates arrested by a third state. The Special Rapporteur collected more than 100 cases adjudicated by 28 states, including the United States of America, which is not party to the UNCLOS. While most of these cases refer to the definition of piracy under customary law, the Convention on the High Seas or the UNCLOS, some other cases involving commercial disputes refer to contracts and define piracy as an act of war. This kind of definition may introduce a lack of coherence in the definition of the term. Concerning the Commission's latest work on the topic, several members of the working group supported the continued development of draft articles on the topic. Others expressed a preference for draft conclusions or draft guidelines. On 22 May 2025, the Commission took note of the oral report of the chair of the working group. This brings me to the end of my presentation. Thank you, Mr. President.
Thank you, Professor SAVADOGO, for the kind introduction to one of the key issues of the day in ocean governance.